Hi, my name is Dagmar Teshale and I'm a tenants' right attorney here at Teshale Law. Welcome to our guide on the unlawful detainer process in California. Here at Teshale Law, we represent tenants that are facing eviction all over California. We created this video series to provide information and guidance to self-represented tenants. This series is also aimed towards those tenants who are not facing an eviction but are seeking to understand the process better for the purposes of making informed decisions about their tenancy to avoid a potential dispute with their landlord in the future. For the purpose of this first video, which is a general overview of the unlawful detainer process from beginning to end, we have decided to discuss the process in 4 different stages. Let's begin. Stage 1. Notice and response. Generally, an eviction will begin with a notice to the tenant from the landlord. Typically, this can be a 3-day notice to pay or quit, a 3-day notice to quit, a 30-day notice to quit, or a 60-day notice to quit. The notice will generally indicate on what basis the landlord is seeking to evict you. After the time period in the notice expires, the landlord will officially file the eviction papers with the court. The court then issues a summons, which the landlord will serve on the tenant together with the complaint. Once served, the tenant has 5 days, excluding weekends and holidays, to take legal action by filing a demur, an answer, or a motion to quash. Filing an answer allows the tenant to present their defenses and objections. Alternatively, a tenant can also file a motion to dismiss, also known as a demur. A demur challenges the legal sufficiency of the complaint by effectively stating that even if all of the allegations by the landlord are assumed to be true, the case still has to be dismissed because the complaint fails to satisfy some legal requirement. Lastly, if you are not properly served with the lawsuit, then one option is to file a motion to quash to effectively assert that you were not properly served and the case can therefore not move forward. Stage 2. Pre-trial preparation. After the tenant files its response, the ball is in the landlord's court to request the trial. During the time leading up to trial, both parties engage in pre-trial preparation to build their respective cases. This phase involves the exchange of information and evidence through the process of discovery. Discovery methods may include interrogatories, requests for production of documents, and depositions. Additionally, parties may engage in motion practice to address legal issues before trial. This is also the time where the parties engage in settlement negotiations in attempts to resolve their disputes without the need for a costly and uncertain trial. Throughout this phase, it's really important for tenants to gather all of their photos, witnesses, documents, and any other evidence in preparation for trial. Stage 3. Trial. If the parties are unable to reach a resolution through settlement negotiations, then the case can proceed to trial. Trials can be conducted either before a judge, a bench trial, or before a jury trial. Either party can demand that the case be heard by a jury. The trial begins with opening statements from both parties, providing an overview of what each party claims the evidence will show. Witnesses are then called to testify, and they undergo questioning from both parties through direct examination and cross-examination. The presentation of evidence, including documents and exhibits, is crucial in establishing each party's case. Finally, closing arguments will allow parties to summarize their positions and persuade the judge or the jury to rule in their favor. Stage 4. After trial. Following the conclusion of the trial, the court issues a judgment determining whether the tenant will be allowed to remain in the property or be required to vacate. If the judgment is unfavorable to the tenant, then the tenant may explore the post-trial options, such as filing an appeal or seeking a stay of execution of judgment. An appeal allows the aggrieved party to challenge the trial court's decision on legal grounds before a higher court. The appellate process involves the submission of written briefs or arguments and a review of the trial record. Seeking a stay of execution may provide temporary relief from eviction while the appeal is pending, but could also allow the tenant to just get some additional time to vacate following the judgment, even if they do not file an appeal. Understanding the unlawful detainer process empowers tenants to navigate the complexities of eviction proceedings effectively. Seeking legal guidance from experienced professionals is essential to protect one's rights and interests throughout the process. And that concludes our general summary of the unlawful detainer process in California. Of course, this video did not go into all of the details of the process. If you want to learn more, please check out our other videos that address each aspect of the process in much more detail. Thank you for watching this video. Remember, knowledge is key in defending your rights as a tenant. Stay informed and seek legal assistance when needed. If you do seek legal assistance, make sure that the firm or the attorney you're considering provides you with information about the amount and the structure of their fees and their success record in previous cases before you decide on whether or not to hire them. We wish you the best moving forward.